NACDL is the association of the nation's criminal defense bar.
Earlier today, somebody told me that I'm a Texan because I'm from Texas. And I said, no, you can't just move to Texas and become a Texan. So I'm actually born and raised in Massachusetts and moved to Texas when I got married. Now, this is not the image many of you may have of Dallas, but this is what got me started on this path to this presentation. My wife, who's from California, refers to where we live as Las Pampas, and that's a sexy way of saying the plains. Other people refer to Dallas as a parking lot because there are no mountains and rivers and all those nice things. I didn't realize that polo was a big thing where I live, or that it was even a thing, but apparently people play polo there in Dallas. And there was one individual, Vaughn Irwin Miller, a real estate executive who had set up a polo team in Dallas, and I guess he invites people from Argentina and from other places to come play polo. And during one of those matches, it was alleged that he hit a polo player, causing him to become unconscious, causing him to get a dozen stitches. And in the words of the polo player, I've never seen anything like that in polo, that somebody would hit somebody on purpose. Now, I don't know much about polo, but when I told Martin Savelli this story, he gasped, and I think this is a very unusual thing. In any event, the case got indicted as a misdemeanor assault, and it went to trial. And that trial, the defense attorney, J. Michael Price, there in Dallas, did a really good job defending his client. When Mr. Cernadas took the stand, he opened the cross-examination by reminding him that this case started out as a civil matter, that there was a good likelihood that had his client paid a settlement, we wouldn't be here in court right now. He reminded him that during the course of civil depositions, Mr. Cernadas had testified in English and he didn't need to use an interpreter. And he went on this line of question on why are we using an interpreter here in the courtroom today. And just watching this, it was very interesting to me, and I didn't know where he was going with it. A little later, he asked him about his client's style of play, and he said, would you say that my client is a spirited player, if I recall correctly? The interpreter in the courtroom interpreted that as, is his client amenazante? In English, amenazante would be threatening. That was just not the right word, and it could have elicited a slew of negative responses. Also, if he had answered no, it could have cut off a whole line of cross-examination. I want to believe that because of the previous questions that had been asked, that this witness was kind of on notice, and that this witness was kind of sitting up in his chair, the state's complainant, and he didn't answer the question, and he waited because he knew that that's not the question that had been asked. And the interpreter caught herself as well in that silence, and she went back and she said, is he fogoso? And fogoso is spirited. That's what was asked. And that was an interesting case where the interpreter admitted her own error, and later that day, or perhaps the next day, the real estate executive was acquitted of the assault. Now, this was a trial that happened back in 2012. I was just hanging around the courthouse. It's something I was able to watch. But I started thinking about this, and it just interested me. And I started looking into this. Interpretation, by its nature, is error-prone. Translation is, you're matching words. When you're interpreting, there's more that goes into it. There's a context. You're trying to listen to dialect. You're trying to get to the right word, but you're also trying to get the sentiment of the statement. It's a process. The assertion that translation by even the most skilled practitioner necessarily distorts the meaning of the translated utterance is universally accepted by linguists. So if you go out there and you read the literature on interpretation and translation, this is not an odd proposition that this is going to be an error-prone process. So when we get to the courtroom and we see poor interpretations, there are usually three drivers for it, I think. There's a growing demand for courtroom interpretation and a shortage of qualified interpreters. Judges who have wide discretion in dealing with interpretation issues too readily sacrifice accuracy in the name of efficiency. And defense attorneys, that's us, fail to anticipate common issues and to preserve objections. No other nation in the world faces as significant an interpretation challenge as the United States at this moment. I look at my own family, my kids, they are Puerto Rican, Dominican, Chinese, Cambodians, and on any given weekend, they're gonna hear Spanish, English, Cambodian, and a dialect of Chinese that not too many people speak. So even when we're in a family setting, sometimes English is the best common language to use. There are many languages spoken across the United States, and sometimes they're just spoken in small communities. Courts try to accommodate this reality, but they really can't. When we look at the best, probably most funded, well-regulated court system, the federal court system, they do have certified, federally certified court interpreters. But even there, the certification is only given for English to Spanish interpretation. It doesn't exist for other languages. And when we look at the standards, we can see that from 1978 to 1991, the federal court interpreter exam for Spanish, that's the written component of the test, was taken by 9,750 presumably bilingual candidates. During that period, only 2,000 passed the written component, and of those 2,015 who went on to take the oral portion, only 388 passed and became federal court interpreters. So there's a difference between someone who's bilingual, someone who speaks English and another language, and an interpreter. It's not the same thing. Bilingualism and being competent to interpret is not the same thing. Many judges don't pick up on that distinction, and they don't understand it very well. These numbers also show you that there aren't a lot of qualified interpreters out there. I was speaking to an interpreter in Dallas and getting ready for this presentation, and she said, "Gabriel, I'm so glad that you're interested in this topic. You'll never believe what the state of Texas is trying to do right now." And I said, "What are they trying to do?" They're saying they're trying to lower the qualifications to get certified as a court interpreter. And she was looking at me and she said, "Why would you do that? I mean, why would you want to increase the error rate?" And I had no good answer for her. The statistics I showed were a bit old, but this is a more recent article written in March 2019, and you can see the title. "At a loss for translators, immigration courts dial up unreliable interpreter services." So what's happening is that people are showing up in immigration courts from places like Central America where they speak Quiche, places like Pakistan where they speak Urdu, Creole, and Haiti, and immigration judges, they have big dockets, they want to start moving their dockets, and they want interpreters in the courtroom. And what the DOJ is suggesting is that we use these call-in services. And again, if you think about what interpretation is, you know that once the interpreter is not in the room and they're on the phone line, that you're just going to get a different quality of interpretation. So that's all a bit of background. For the purposes of this presentation and what we're learning about at this conference, I think it's important to keep in mind that poor courtroom interpretation has a substantive effect on a defendant's constitutional rights. This thing, the Bill of Rights, Fifth Amendment right to due process, and sometimes the Sixth Amendment right to confrontation. So when you're in the courtroom and you're confronted with an issue related to interpretation, you want to start thinking about it in terms of due process and Sixth Amendment right to confrontation. And also when you're getting ready for trial, these are things that you need to start anticipating. The landmark case is United States ex rel Negron versus the state of New York. It's a case out of the Second Circuit that was issued in the 1970s. And there, the issue was that there was a defendant who was on trial for murder, Puerto Rican, just like me. And he had just come from Puerto Rico. He was in Riverhead, New York, working on a farm, got into a dispute with someone, and someone died. At his trial, the attorney, although the judge knew and his attorney knew, and the prosecutor knew that he didn't speak English, his attorney did not request for the appointment of an interpreter. Now, the prosecutor did have an interpreter, Miss Magapinto, and Miss Magapinto, during the trial, would interpret for the court. I think there were 14 witnesses called at this trial, and 2 of them were Spanish speakers. And when they testified, she interpreted the testimony for the court. During the arraignment, she also read the indictment to the defendant. So the court was on notice, and there was an interpreter available, but not used during the course of the trial. So during this trial, Mr. Negron sat next to his attorney. He could see that there were about 12 people who testified against him, but he couldn't hear and understand what they were saying. And certainly not in a way that he could assist his attorney in real time. Over the course of a 4-day trial, the interpreter would sometimes run over to the jail, and she would meet with the defendant and his attorney, and she would just summarize what the witnesses had testified to during that day's trial proceedings. And she'd give them 15 or 20 minutes of her time. At other times, the interpreter would just stay home, and she'd be on call if the court needed her. And sometimes she would even come to the courtroom, but she would sit and she wouldn't interpret the proceedings for Mr. Negron. And the Second Circuit, in view of these facts, just thought it was a bridge too far to cross. And they said that this violated basic notions of fairness, due process, and also his right to confrontation and to assist his counsel during this trial. Now, these issues, I think, are on everyone's radar. You know, if you have a defendant who doesn't speak English, he may need an interpreter. But then the issues of how to deal with foreign language witnesses and evidence, I think these are tricky issues. And we need to anticipate these issues. If you're going into trial and you know that there's going to be evidence against your client in a foreign language, then it's important to understand what the statutory framework is for the admission of that evidence. It's important to prepare the cross-examination of witnesses, and it's important to start thinking about how that evidence is going to come in. It's going to come in through an interpreter. Who is that person? Where's that person coming from? Do they have bias? So it's important to know the rules. In federal courts, we have the Courts Interpreters Act. It's 28 U.S.C. 1827. This instructs federal judges that only in a case in which no certified interpreter is reasonably available may the services of otherwise qualified interpreters be used. As I stated, the only certified interpreters are going to be Spanish interpreters if you're in the federal system. That means that if you're going to trial in Long Beach, where there's a big Cambodian population, or in Houston, where there's a big Vietnamese population, or even the Northern District of Texas, which is one of the fastest growing places right now in the country, and we're getting a lot of Asian migrants, that chances are that the interpreter who shows up to translate at that proceeding is not going to be a certified interpreter. When such a situation arises upon motion of either party, a litigant may request an electronic recording of the proceedings. I was speaking to Martin and preparing this presentation, and he was telling me, I just asked that when a Spanish-speaking witness is testifying that the court just record it because I want to create a record. And I said, oh, you're using this law here. And he said, yeah. And to him, it's intuitive, and it has to become intuitive for us. We have to prepare for these things. In Texas, if I'm in a Texas state proceeding, the government code is going to apply, maybe. I'm going to have the Texas Code of Criminal Procedure, and I'm going to also have the Texas Rule of Evidence that may help me at certain times. The government code sets out a framework for certified interpreters, and it requires licensing for certain interpreters in certain places. That means that if I'm in Dallas or I'm in Houston, the court may have an obligation to provide a certified interpreter for that proceeding. But if I'm in a rural county, well, the government code's not going to help because it goes by population of 50,000 or more. So the Texas Code of Criminal Procedure could be read to be in conflict with the government code. It could be read to just supersede it and weaken it. But it says that any person may be subpoenaed, attached, or recognized in any criminal action or proceeding to appear before the proper judge or court to act as an interpreter. Now, the Code of Criminal Procedure does lay out a framework where a party can contest the appointment of the interpreter. It can challenge their qualifications, and it can even ask the court to appoint another person to act as an intermediary between the witness, the interpreter, and the court. Texas Rule of Evidence 1009 basically lays out a procedure if you're going to admit a transcript during a trial, and you're going to say, look, they're going to come in with this videotape of my client speaking Spanish. I had this translated. Here's a certified transcript, Your Honor. I'd like to move for the admission of this into evidence at the appropriate time. Well, if you got working on that a few days before trial, you may be out of luck because that had to be presented to the court 45 days before trial. That's an important rule of evidence that's going to probably help you, but it's going to hurt you if you just didn't know about it. Rely on the Sixth Amendment's Confrontation Clause. I was reading a recent issue of The Champion, and in it, it started with a line that Scalia apparently had once said that criminal defense attorneys should build a statue in his honor because he's revived this clause. If the government intends to present testimony regarding interpreted statements of your client, you may have a Sixth Amendment objection. There's something called the language conduit theory. So you can imagine a situation where you might be representing someone who flew into JFK. They don't speak English very well. DEA took them aside. The DEA agent doesn't speak their language. They called up an interpretation service. Certified interpreter got on the line. DEA agent asked questions. The person who is now your client answered those questions. He may have even signed the form for the DEA agent there. And then at trial, those are going to be brought in, and those are going to be admissions of a party opponent. Now, a lot of courts have looked at this situation and said, well, we have the language conduit theory. We're going to look at issues of reliability. We're just going to treat this as an issue of agency. That interpreter was there working for the benefit of your client, and your client had every reason to participate and be truthful, and that was his agent, so those are his admissions. Well, not so fast. At least the 11th Circuit has looked at this issue after Crawford, and it said, no, we think this implicates the right to confrontation. The person who needs to come to court is not that DEA agent, but it's going to be that interpreter. You have the right to cross-examine that interpreter to see whether that's actually what your client said. So don't forget about the Sixth Amendment and your right to confront witnesses and have them present at trial. When you're preparing, it's going to be important to anticipate hurdles and contest the admission of foreign language evidence. Courts don't automatically allow the introduction or publication of foreign language evidence. This is a lesson that can be gleaned from this case here, United States versus Para Perez. There was a witness on the stand, a material witness to the government's case who was testifying. The attorney wanted to impeach that witness with a recording that was in a foreign language. And when he moved to impeach the witness with the recording, the court said, hold on, I'm not publishing that foreign language recording to the jury. We have a translation of it. You were able to use that. You used the testimony of an investigator, and you impeached them in that way. But we're not going to publish this now, and we're not going to play it here in court and allow you to sow confusion. And that fell within the trial court's discretion to do. So that could have limited the ability to cross-examine that witness, and certainly the defense did feel that it limited their ability to cross-examine that witness. But then you have the inverse scenario, and it's usually the statements of your clients have been recorded, and they've been recorded in a foreign language. Now, in this Texas proceeding, the defense attorney wasn't looking at the government code, apparently, wasn't looking at the Texas rules of evidence, and didn't do the work that was necessary pre-trial to kind of head off this issue. So in this case, Castrejon v. State, there was a vice officer who arrested the person who became the defendant at the trial. And in the course of that arrest, she spoke to him in Spanish and English. Now, Officer Dawes, that was her name, she admits she's not fluent in Spanish, but she can get the job done because she's been working as an officer for 20 years. And she told the court, I've encountered a lot of Hispanic individuals in my capacity as an officer, and I've communicated with them. In the court opinion, it says, I can get my point across. Well, the defense had some issue with how she was interpreting statements that were recorded. But the defendant's attorney didn't engage his own interpreter. He didn't prepare a written translation for the court. He didn't share that with the government 45 days before. So then when he showed up at trial and he wanted to contest how this officer, Dawes, was interpreting what his client had said, he didn't have the ammunition. He hadn't laid the groundwork for it. The trial judge, who has wide discretion here, looked at the issue, and who are they going to rely on now? Now they're going to rely on the officer. And what's the officer saying? Yeah, through my training and experience, I speak Spanish. I could understand them. I remember what I said. Here's what I said. Here's what he said. The judge said, that's fine. We have a live witness here who can explain what's on the tape. Now I'm going to let that recording in, and this witness is going to explain to the jury what's on that recording. This all could have been avoided with just some prep work and relying on the rules of evidence that Texas provides in a reasonable way. When these issues come up at trial, I think judges are going to be caught off guard. They're trying to move things along. As I said earlier, it's about efficiency. It's not about accuracy. And they're going to come up with ad hoc procedures. So what you can do is think about issues that may come up and try to litigate them pre-trial through pre-trial motions. This is a case that took place in Austin in 2013. It was alleged that some individuals working with the Zeta cartel in Mexico had laundered money through the American quarter horse racing industry. And this trial was going to be a multi-week trial. It was going to be a very long trial. It was going to involve individuals coming from Mexico to testify, and they were going to testify in Spanish. So obviously, there were going to be a lot of issues with interpretation and interpreters during the course of this trial. One thing that started happening early in the trial is that questions would be asked of a witness. The witness would answer the question in Spanish. The lawyer would hear the answer and object. Well, at this point, the judge, who's not a Spanish speaker, he hasn't heard the response. The lawyer is saying that this is objectionable. and he wants the jury to leave the courtroom, and he wants to make an offer of proof to the court and kind of argue this outside the presence of the jury. The judge got tired of this, and he said, no, that's not the way we're going to do it. We're going to let the answer come in. We'll interpret it, okay? Then I'll hear your objection after I know what's going on, and then we'll resolve it this way. So basically, the lawyer knows that there's going to be something really damaging coming in, something really prejudicial perhaps, something that's against the rules of evidence, and the court is saying, just let it come in and then we'll deal with it. Now, I was discussing this scenario earlier, and another attorney told me, well, what you're asking for is a windfall for the defendant, right? Because if this was just a scenario in English, well, the jury would hear the answer. And I'm saying, yes, I'm asking for a windfall, because if we can head it off and we can convince the judge to use an alternate procedure that's going to benefit us, then we should. The Fifth Circuit looked at this issue and agreed that the district judge's conduct of the trial in this manner was problematic and may amount to an abuse of discretion, but ultimately found the error harmless. So one of the best things I ever learned about abuse of discretion is that when you read an abuse of discretion case, it really doesn't mean anything. It could have gone one way or the other. So try to have it go your way. Remember that the interpreter is an expert. Under the Federal Rules of Evidence, Rule of Evidence 604, they have to be qualified in order to be up there and interpreting. So if you're going to challenge the expert, you may need your own expert. And again, that may be done through some pretrial litigation. The trial judge is probably going to defer to the expert at hand, who's the interpreter. The interpreter, who you're trying to challenge, may not take your position, obviously, but if you don't have your own independent interpreter, who's the judge going to believe? So one of the things to be mindful of is if you think there's going to be an issue with interpretation, or you want to look into it, or you start thinking of this interpreter as an expert, treat him like you would any expert. Ask for their qualifications, do some pretrial litigation. You may even want to inquire whether the government's going to be bringing their own interpreters into the courtroom, interpreters who probably worked with these witnesses, interpreters who've kind of learned the script. And talking about this with Martin, he was telling me that there was a situation where he was cross-examining a witness, and the witness just didn't give the answer that he was supposed to give. The interpreter who'd been working with the witness and the government knew this. The interpreter didn't interpret what the witness said. The interpreter stalled, the interpreter hedged, and Martin caught this and approached the judge, and they litigated the issue. He's gone a step further. He's had the interpreter stricken and had the court appoint another interpreter to come into the courtroom. In People v. Alvarez, there's a case out of California in 1996. The defendant, who was Cuban, testified in English, and he was having a lot of trouble with his testimony. I guess the messages were getting to him in his language, but he wanted to speak in English. And on appeal, the lawyers argued that what he should have been receiving was simultaneous translation, not consecutive translation, while he was testifying. And the Court of Appeal said, no, we don't agree, because the interpreter explained to the trial judge why he couldn't do simultaneous translation. Well, I'm not sure that he should have been getting anything but consecutive translation. That's when you hear a group of words and you interpret them for the individual who doesn't understand the language. Simultaneous translation is what we see at the United Nations when people are wearing their headsets. Someone is speaking and the interpreter is interpreting in a constant stream. In a courtroom, that's what the defendant gets when he's sitting next to his attorney and he's not testifying. When someone's on the stand, usually it's going to be consecutive. The point here, though, is that if you're arguing that your client needs something else, then you got to bring a little more than this is what my client says he needs. You might need to bring an expert who can say, yeah, under these circumstances, this might be appropriate. And if this person says this is what he needs, this is what we should do. And if this interpreter is saying they can't do it, maybe that's a deficiency with this interpreter, not with interpreters or interpretation in general. Finally, seek assistance of a foreign language individual to monitor trial proceedings. If you're representing someone who doesn't speak English and you don't speak their language, and there's going to be an interpreter involved, when we go back and we embrace the concept that this is an error-prone process, that it's going to be a subjective process, you might want to have a second pair of ears there, someone who's listening and someone who can tell you, hey, that didn't go right. This case, I think a lot of us know it. It's about the Abacus Bank in New York. It was a bank that operated in Chinatown after the recent recession. It's the only bank that got prosecuted. It's the only one that the government could find to prosecute, I suppose. And rightly so, the family who ran this bank and served their community, they were indignant and they went to trial to fight this injustice. They won at trial. But a lot of the evidence that came in from foreign speaking individuals. And there was a reporter for The New Yorker who sat and monitored the trial, which was of vital interest to the Chinese American community. And right here, it's probably too small to see, but I'll just read it out. Frequent translation problems complicated matters even more. In New York courts, budget constraints have limited the hiring of interpreters, which has led to scrutiny from lawyers' associations. Because transcripts of trials are entirely in English, there is no permanent record of what was said in other languages. At times during the trial, it was unclear how much unintelligibility was caused by mistranslation and how much by the deliberate indirection of witnesses. On one occasion, a prosecutor, trying to get to the bottom of a previous mistranslation, asked a witness, "The interpreter didn't know what the word everything means?" Then heard the interpreter mistranslate this question into Mandarin as, "Why didn't the interpreter interpret everything?" Few people involved in the case were in a position to know that the translation had gone awry. But 3 reporters who were covering the trial for Chinese language papers were very familiar with the problem. "This is physically painful to listen to," a reporter for Singtao Daily whispered at one point. When a lawyer asked a witness, "Isn't it true that you have no problem lying when it's in your interest to do so?" the interpreter rendered it as, "Doesn't it harm your overall interest to lie?" The bank's lawyers did not speak Chinese, and the mistake entered the official record. Now, they got an acquittal, and ultimately it didn't matter in this case, but it might matter in yours. So thank you for your time. I hope this puts this issue on your radar and you guys can follow up on it and take it a bit further than I have in these few minutes I've had. Thank you.